Good morning, Chattanooga. This is Jim McCoon, your host of Legal Bytes. And I want to welcome you to another weekly edition of the show that talks about legal issues, some current, some that just apply to your business or to things that you and your family are dealing with. Well, our whole goal here is to try to assist you in navigating life as the law may apply to it. And I've got as our guest and co-host today, Trevor Ashley. Hello, Trevor.
Hey, Jim. Good morning. Thank you for having me.
Yeah. Now, Trevor, I had asked you to come on today to talk about some common issues and means of addressing estate planning issues. But since you and I talked, there has been just a whole cornucopia of recent cases that are just so interesting that they're on my mind. And if you don't mind, I'd like to talk a little bit about them before we get to any of your estate planning topics. Is that all right?
Absolutely. Yes.
I mean, for example, I heard, I guess, driving in this morning that President Trump has now been sued on a third time under a rarely used or considered provision of the U.S. Constitution. Did you see that?
I have, and I guess this issue has sort of been lingering since he took office. There's been a lot of news reports that concerned citizens have been filing actions against President Trump, essentially alleging that he's violating a provision of the Constitution that most of us probably didn't know even existed, and now has been commonly referred to as let me make sure I pronounce this correctly.
That's what I'm saying. I can't even say it, much less commonly think about it.
Well, this probably nobody ever even heard of this word. It's not used in common parlance. Emolument clause, which is a provision included in Article 1 of the Constitution, prohibiting Article 1 generally applies to the legislature, U.S. Congress. So generally prohibiting members of the U.S. Congress from having any title of nobility appointed by a foreign government or accepting any type of present emoluments, just an old term for payment or some type of perk from a foreign government for doing some type of work or receiving some type of interest from a foreign government. Right.
So, and as I understand it, at least in the prior suits against the president on this issue, he's taken a position that doesn't apply to the presidency.
And that's, I think, a very reasonable position to take. This is found in Article 1 of the Constitution. Article 1 applies, like I said, to the U.S. Congress. Article 2 applies to the chief executive, what we refer to as the U.S. president. So I think that there is a reasonable basis for that argument.
Well, and the other aspect of it, at least it would seem to me, is what I've heard is a lot of the allegations are that supposedly President Trump's, at least one of his entities that was developing a hotel, received funding through Russian sources as for the construction and development of the facility. And it seems to me that if that's the case, that's also not the president receiving anything. It's his developmental or hotel owning entity, which would be, at least under the laws of the United States, a separate person for the purposes of being recognized legally.
Well, that's correct. I suppose the counter argument is that they're asserting he owns either a majority or total equitable interest in that entity. And so they're, I guess, arguing that you should just look through the corporate form there and apply the rule to the shareholder. Of course, we know from our law, it's very unusual to do. It appears in, quote unquote, piercing the corporate veil type situation. But no, I agree with you. I would also state that this emolument clause, at least the text as written, appears only to apply to individuals acting in their official representative capacity.
So if the senator from Minnesota becomes the Duke of Edinburgh, then that would violate.
Correct. Absolutely. That would, just by the clear text, that would be prohibited under this provision of the Constitution.
Okay. Or if, again, a senator receives gifts from the Queen of England, would that violate the emolument clause?
The way this is written, I believe so, yes, because unless they cannot do it without the consent of Congress, it says, except any present. So I think that would apply.
Okay. So I guess the reason why it's in Article 1 pertaining to our lawmakers, as opposed to an Article 2 pertaining to our head of state, is because at the time the Constitution was written, kings and heads of state all over the world would give tribute or gifts to other heads of state as a matter of custom and practice.
I believe that's correct. And I mean, I think the clear intention of this provision is to prohibit a legislator from accepting a gift and then trying to enact legislation, is essentially in exchange for receiving a gift or some type of payment from a foreign government. And it's intended to ensure that the legislator's loyalties lie only with the United States as opposed to doing work on behalf of a foreign government.
And of course, at the time the Constitution was written, we had much fewer states. So the legislature was controlled by a much fewer number of people. So an individual who had received some tribute or payment from a foreign country could exert much more control over a smaller body, being a big fish in a small pond, basically, if you chose the right person to give the gift to or tribute to.
Well,
so if you look
correct.
at it just historically, but I mean, now with 50 states and 2 senators from each state, and I don't know, each state has a different number of representatives, but you end up with a huge Congress where one individual receiving a gift really doesn't have a whole lot of control over the entire Congress.
That's certainly possible. There are situations where, for example, in the Senate with the filibuster, where once you might remember where Senator Lieberman exerted a lot of influence over the healthcare debate by essentially abstaining and saying he was going to not vote to lift the filibuster. And so a lot of modifications were made to the healthcare bill in order to get him to come on board, to allow them to vote for the 60 senators.
Right.
So there are certainly situations, especially in the Senate, where the minority or 1 or 2 senators can exert more influence. But in general, I agree with you. Yes, that is true.
So that certainly is one case that was recently filed that has had some impact. And then, I was reading an article, I believe it was out of the state of Washington, where a single mom called 911. She had, I think it was 4 or 5 children, was pregnant at the time, living in an apartment, and she called 911 because there was a burglary she believed to be ongoing at the time. And when the police arrived, she came out of the apartment, is at least in the brief article that I read, and she had a butcher knife in her hand because she was trying to protect her children, and she was shot and killed.
By the police?
By the police. And so first thoughts came to my mind was, of course, how tragic and how horrible. And there's all kinds of outcries right now going on with respect to the shooting. And the police now, of course, have got dredged back something they wouldn't have known at the time of the call, but they've dredged back that she had been getting some treatment in the past over some issues she was having mentally or emotionally. And so now they're trying to say that they were concerned that she might have been needing further treatment and had been out of control. And this, to me, that's make weight. Now, there's no way an officer could have assessed the situation, or they all wear tase guns now. Why, you've got a pregnant woman with a butcher knife and 4 children at least. I can't remember again if it was 4 or 5 minor children she had in the home. And she comes out, and, at that point in time, why you had to fire your weapon, but couldn't at a minimum taser if you couldn't just talk her out of the situation, to me, is just absurd. But what came to my mind was, if that happened in Chattanooga, what kind of claim or suit would be filed as a result of the wrongful death of that mother on behalf of all those children? And of course, also the claim for the unborn, who, depending upon how far the child was, that unborn life that was taken.
Did the in utero child did not survive?
I have not seen anything to say that it did. So I'm assuming that it was lost as well. So you're sitting there and you're thinking, what would you do if that happened in Chattanooga, Tennessee? And of course, we've got basically, and a lot of people might not know this, but there are a myriad of state claims, but really the best two avenues, I think, would be under what we call the Governmental Tort Liability Act would be one angle. And that's because we go back a long way to England, but the government is immune from litigation unless it consents to being sued. And so you've got the Governmental Tort Liability Act, we all refer to as the GTLA, which would provide certain exceptions to the immunity. But the problem with that is when you look at the GTLA only basically allows for the exceptions to sue the government where it was a negligent action and the employee was taking the action in the course and scope of their employment.
So that would be a situation, for example, if a police officer was operating his vehicle and had a traffic accident.
Sure.
And he injured another driver. The other driver could sue the city under the GTLA.
Right. The GTLA, in fact, has a specific exception for motor vehicle accidents. Or if, let's say, in the situation of this poor mother, if the officer was coming down the hall and tripped on the stairs of the apartment complex and fell, and the revolver went off such that, she was shot and killed accidentally. But here, where there was an intentional firing of the weapon, at least from all accounts, because of their concerns and the fear that she was not in control with the weapon and they were in fear of their own safety, then I think you're basically out of the GTLA because it was an intentional act. They may not have intended to kill her, but they intended to fire the weapon. And there are plenty of cases where you look to the act, not the result, as to whether what was intended.
Yeah, I remember from law school, there's a legal concept called transferred intent, where the police officer's defense could be, I didn't intend to shoot the homeowner, I intended to shoot the burglar.
Mm-hmm.
And I think the law would say, well, like you're describing, you intended to discharge your weapon and to shoot somebody.
You just didn't intend the consequence.
Correct. So you had the requisite intent for the action.
Right. So, if you can't bring basically a GTLA or a tort liability action for what the officer did to this poor widow, and leaving, and the claims that all the children would have for the loss of their mother and their provider, then what would you do? And that's where I think you have to turn to a federal statute, which is commonly referred to as a Section 1983 action. And under 1983, basically you've got to prove, in essence, two things. You've got to establish, one, that the person was being deprived of a federal, either statutory or constitutional right. And two, you got to prove that it was being done and as a result of someone acting under color of state law. So here in this situation, what you would assert is that there was a seizure when that officer pointed the weapon at her. And then, of course, when that officer fired and hit her with the weapon, there was a seizure of the person.
So that's let's talk about that for a second. Interesting concept. Normally when a lot of listeners probably hear the word seizure, they're thinking of physically grabbing somebody and holding them.
Or actually, I think more of seizing or confiscating
property. Right.
Yeah, you think of,
absolutely, right.
For the fishermen that are out there commercially fishing without a license and they have their boat and all their gear seized.
Right.
Or, you talk about the drug lords, and whenever there's a federal prosecution, they come in, they seize their bank accounts, they seize all the money that's in the house, they seize the drugs, they seize the world on those kind of cases. So, that's what you don't think, man. I agree that it's an unusual concept, but actually whenever you draw down on an individual, or if you fire upon them and the act would be an assault and battery in normal parlance. If I pulled a gun on you, then I have an assault because I've threatened you with a weapon. And if I actually shoot you, then I've got a battery to your body because I've harmed you. But in constitutional parlance, there is a seizure.
So it's actually a law enforcement officer seizing the individual. It's similar to an arrest.
Correct. Right. That person, the intent is to stop their freedom of movement.
And I guess, whether one action constitutes a seizure or not depends upon the level of the interruption of freedom of movement.
Yeah. Although, and what's interesting is Section 1983, if you read the statute, there is no mental intent, or what sometimes the listeners may have heard that, if you watch Perry Mason, no mens rea, no intent to do the things. But the cases clearly provide, as they've interpreted 1983 over the years, that there is an intent element. So, if the officer had their gun out and was cleaning it, and a person saw the weapon out and it caused them to be afraid that they were being under arrest or that the gun was intended for their purpose, I think that might not be sustained because the officer was, and they'll have to be proved, but the officer was doing something other than the intent to seize or arrest or halt that person's activities.
So a police normally, like a lot of times when listeners probably think of use of firearms, particularly by just a normal individual, they think of a self-defense type situation. Certainly a police officer is entitled to use his weapon for self-defense, but what you're also saying is that a police officer is entitled to use his weapon to actually take someone into custody, to seize them, stop them,
sure,
and use deadly force to the extent it's necessary to effect that seizure.
Sure. Anyone who's watched the show on TV has seen officers pull their weapon, draw their weapon from the holster, and go in and actually, what's the term, draw down on an individual and tell them they're under arrest, hold it, hands up, all those kinds of things. And that is a seizure. And the question is whether or not there's an unreasonable use of force, was an improper use of the weapon, or was it an improper seizure? Was it basically a false arrest?
So the Constitution protects citizens, the Fourth Amendment, from unreasonable searches and seizures.
Correct.
So the question you get down to is whether this was a reasonable seizure.
Right. And, there you get into the assessment of situation, at least from everything that was in the report that I was able to read. And I think it was yesterday or perhaps it was the day before, where this pregnant single mother of 4 called 911, had the officers coming to her assistance, and they ended up shooting and killing her because she's in the hallway trying to get them to protect her children. And I think the article said trying to get them to transfer them to her sister so that they could be protected. Under all the assessment of that situation, was it appropriate, reasonable for those officers to be in fear of either a person in the public or in fear of their own injuries, such that they were authorized to use such deadly force?
That's from the way it's been described during our show. You mentioned a continuum of force earlier, where police officers are trained to, not start immediately with a lethal weapon to stop someone from committing an act. There's a question whether or not the officers properly followed their continuum of force and how they were addressing this lady. I presume they must have thought she was the burglar.
It's not clear. I don't know if they thought she was the burglar or if they thought that she was deranged with this butcher knife, and it was necessary to subdue her with deadly force for the purposes of protecting the other officers or the other people in the department. It just was not clear.
I think that's a very tragic situation that occurred there.
Oh, it was. And so I was thinking, okay, well, in that kind of situation, what would you do? And of course, what's interesting is, as we as lawyers, when we go in, we don't know all the facts. That's why you get discovery, subpoena power, all those things that go into a lawsuit, but we are required by law to do a reasonable investigation prior to filing suit. We had that duty, and we can't just go off half-cocked and file claims that aren't, at least based upon our investigation, meritorious. And, so when you get into that situation, there are things that, at least in seeking to pursue either a 1983 claim or a GTLA tort claim for negligence under state law, you can do. And of course, you got the Open Records Act, which allows individuals to file a request for open records in which you're to receive a response within 7 days from the governmental entity. And that's something that if you ever are in that situation, your attorney will know to do basically 2 things when you walk in the door and retain him: is 1, to put out a formal notice of potential claims to the governmental entity that's involved, say it's the police department, sheriff's department, whoever it is, to, in that initial writing, because you put them on notice that a potential claim exists, to do what's called a non-expoliation letter, which basically says, non-spoliation letter, which is basically to preserve the integrity and the existence of all potential evidence. And, lawyers normally go beyond that and say specifically areas that should be include, for example, electronic information, anything that's on hard drives, anything that's on cell phones, text messages. Officers are all the time texting back and forth. Any cell phone voicemails that may have been left where they weren't able to reach one another. Personnel files, complete personnel files of the individuals involved. Why? Because not only in those cases are you looking at the individual officer or representative and what they may have done. For example, in this situation where the woman was shot, were they a problem officer? Had they been prior disciplines? Those kind of things.
And I would think too that you'd have a question. For example, if they were wearing body cameras, you'd want the law enforcement agency to preserve that evidence.
Body cameras, car cameras, all that kind of information.
The radio communications they had.
Radio dispatch records. If there was a 911, preserve that. The dispatch records from the officers dispatch, what the officers are responding and saying. The timelines, so often the timelines of the sequencing is very important. I mean, I've seen cases where from the beginning of a chase to the end of a chase to the actual shooting of the individual in their car. This was a case that was up, I believe, in Coffee County. Less than 7 minutes had transpired. The officers had searchlights on their cars. They had them turned the other way so they couldn't see. They had body camera on, and at certain critical times, they turned their body cameras and their mics off. So there was no data being recorded.
Oh, wow.
And the individual ended up having, I believe there were 14 shots into the car. And I think 4 went into the individual who was unarmed, who was sitting there without doing anything and was killed. So, those kinds of things happen. And so the timing, a lot of times is very important. So getting the dispatch records and the data showing, because they know exactly where the officers are at a certain time when they're on a call and what's occurring. All that information is asked to be preserved. And then the second thing, when you hire a lawyer, use the Open Records Act to seek that information, as well as any internal investigation records, because, with a shooting or discharge and drawing and discharge of a firearm, most protocols require that an internal investigation occur with respect to the acts of the officers, justification, and the like.
Jim, I actually have an interesting point to talk to you about officer shootings, but we're about out of time for our first half. Let's pick it up in the second half.
All right. Thank you very much. We'll talk to you on the other half of the hour after news and a break. Thank you.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
3, 2, 1.
Chattanooga Radio, AM 1240 and 92.7 FM's news now.
Cops say a man was shot by his roommate at East Lake Courts. 26-year-old Jamal Thomas was hit by gunfire. His roommate, Dominique Barnes, has been charged with attempted first-degree murder, aggravated assault, and possession of a firearm during the commission of a dangerous felony. Cops say this all started because of an argument that became violent. Suspect Dominique Barnes still somewhere on the loose and potentially armed. More details in the Chattanooga double homicide case in which former city councilman Manny Rico discovered 2 dead bodies in the Highland Memorial Gardens Cemetery. Police now confirm both of those bodies were shot. The police called in the police academy to assist in the search, a wonderful learning opportunity for the cadets. They've extended the crime scene to cover the area beyond the Memorial Highland Gardens. Lee Howard has been arrested after a burglary at the Red Roof Inn on William Street. The 24-year-old is charged with aggravated burglary and theft of property over $1,000 after the police say he broke into rooms and stole purses. Russell Stroud, Nooga Radio News, now.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
Expect cloudy and warm weather out there through your afternoon. A shower or two will move in from the south. Highs 82 to 85 tonight. More scattered showers, overnight lows near 70. For Thursday, a wet day with scattered showers and thunder showers. Highs closer to 80. Another round of showers and storms late Friday. Celebrate Independence Day with Big Shots Fireworks in Calhoun, Georgia. Exit 312 off I-75, 3 miles west toward Rome on Highway 53. Open daily, Big Shots Fireworks in Calhoun and now in Adairsville. And I'm Smorsine 12 Chief Meteorologist Patrick Core. On Nooga Radio, AM 1240 and 92.7 FM.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
McCune, Williams & Ashley PLLC offers a full array of legal services to meet the needs of businesses and individuals. Our attorneys represent diverse backgrounds, interests, and legal emphasis, but we share one common goal: providing the highest quality legal services to our clients through the combination of our talents, experience, and expertise. In each case, we strive to tailor those services to meet each client's specific circumstances. Business law, business organization, civil litigation, commercial litigation, conservatorship and guardian law, bankruptcy law, just to name a few. With over 188 years of combined experience, McCune Williams Ashley PLLC is here to help you and your business succeed. MWALawfirm.com. That's MWALawfirm.com. Call 423-756-6400. That's 423-756-6400.
Picture that curl of steam rising from your fresh-made pizza. And in a flash, let it take you aloft, teasing all your senses. I'm talking about Jet's Pizza. If you eat out at Jet's in Hickson or take home your steaming deep dish square pizza, you'll love Jet's. They used only the best ingredients in a family recipe. Also try the cheesy bread, wings, chicken, or bread with bacon, antipasta, or Greek salad. Jet's Pizza at Buy Low near the S-Curves. Open till 10 p.m. Sunday through Thursday and 11 p.m. Friday and Saturday. You can order online or have it delivered. jetspizza.com. That's jetspizza.com. Or call them now. They'll have it ready when you get there. 757-1616. That's 757-1616.
Jet's Pizza, the best pizza in town. 3600 Hickson Pike.
Life is short. Eat better pizza.
Let's get Jets.
Hi, this is Nadia behind the green door. You've had ice cream and you've had shaved ice, but have you had snow cream? It is amazing. It's light, airy, fruity snowflakes melting on your tongue. You need to come and see us. Highway 58, green door next to Hardee's.
Nooga Radio, AM 1240 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree? Call 423-800-8949. 800-8949. Nooga Radio, AM 1240, 92.7 FM, and 95.3 HD4. News, talk, sports. Nooga Radio. The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Welcome back to the last half hour of Legal Bytes. That's BYTES, which is a measure or segment of information. And in this situation, we hope that it is legal information that you can use. This is Jim McCune, your host, and Trevor Ashley, and we came in today to talk about some common issues that have to be addressed in estate planning, but there's been so much in the news lately with respect to President Trump being sued again, to officer shootings of a single mother, pregnant mother, and killing her, to just so much happening that, you know, we've sort of been sidetracked, and we may get to some of the state issues before we leave today, but we were currently talking about with respect to the shooting of the mother, and again, I think it was in Washington State, how that would be handled and what would you do here in Chattanooga. And we were talking about a Section 1983 claim, which is a federal statute. And in that situation, the other good part about bringing a 1983 claim is there's a provision to obtain your attorney's fees if you prevail under Section 1988. And the court at that time can consider the time spent, the results obtained, and the like in determining an award of attorney's fees. And what that would do for the claimant or litigant that's successful in showing that under color of state law, a representative or the state itself took steps to violate their constitutional or statutory federal rights.
Jim,
it lets them get, it lets them get the full amount of the judgment, and it's not none of the attorney's fees are necessarily taken out of it because there's a second award just for the attorney's fees.
Let me ask you a question about these types of action. If the officer is subsequently indicted or there's some sort of administrative proceeding, and the police officer is either acquitted at trial or through some administrative procedure is found to have acted in compliance with whatever the procedures were in place, does that have any type of preclusive effect for the 1983 action?
Well, if you're the government, you'd say it does, but it doesn't actually. In fact, O.J. Simpson, we all were glued to the television years ago. If you were old enough to watch the criminal proceedings with O.J. Simpson regarding the allegations of murder in California and his subsequent acquittal, if it doesn't fit, you must acquit. But after that, Nicole's family brought an action against OJ civilly and was successful and received a very large judgment against him, which resulted in the start, I think, of his downfall financially and ultimate subsequent charges for theft and them serving time and all those things that happened. And the reason why is because in the criminal proceeding, the burden of proof is much higher than in a civil proceeding. So, your juror it doesn't have a preclusive effect if you are acquitted criminally. Now, if you're convicted criminally, it does have some effect on the civil proceeding. But if you're acquitted, it does not, because you go from beyond a reasonable doubt to, in most cases, the preponderance of the evidence, although in some cases it may have a higher standard, but still it's not beyond a reasonable doubt.
Beyond a reasonable doubt is the strictest standard in the United States.
Right. And we use that because what's the old story? We'd rather have 100 guilty men walk free than one innocent man convicted. And so what we do is our system is set up to protect the innocent. And so we made the burden upon the state in prosecuting criminal charges very high.
And so an acquittal won't operate to preclude or have any effect on the civil action. But you mentioned that a guilty verdict in the criminal action would have some preclusive effect in the civil action. I assume that would operate against the officer or against the state in that situation.
Yes, because there would be determinations beyond a reasonable doubt of the elements of the crime. Now, all the elements of the crime may not sufficiently establish the elements of the tort claim that's being brought or the statutory violation. So that's what I said, it would have some effect, but it's more issue preclusion as opposed to res judicata. It will preclude relitigation of issues that have already been established criminally.
So it wouldn't necessarily guarantee a result in a civil action, but it would certainly provide a basis for precluding the state from relitigating issues already resolved in the criminal case.
I believe there will be early settlement discussions.
So that's an interesting, the way you have to look at those things. The average person may not realize that, the different effect, the different outcomes might have on the underlying civil action.
Right. Oh, I agree. And that's why, I guess we go to school for 3 years and then still call it practicing, even though we're done it 35, 40 years, is because things are always changing. You've got to know the issues and every case is different. So
absolutely. That's right. And, same reason they say doctors practice medicine. You're always learning.
Yeah. Now, there was an interesting case down in Georgia you were mentioning to me, Trevor, that recently came down that was in the same area, talking about the immunity of the state and bringing claims because the state was not doing or representatives of the state were not acting properly.
Well, that's correct. This was in yesterday's Chattanooga Times Free Press. It's an article covering a decision out of the state of Georgia where the ACLU had challenged, had sued some government officials in their official representative capacity alleging that the application of this new abortion ban that they had instituted was unconstitutional. And the court there held that because there was no express waiver by the legislature permitting this type of action against these government officials, that the action was barred by sovereign immunity. But then the court went on to hold that individuals could sue them individually, essentially to enjoin them from carrying out an unconstitutional law.
Right. And you can also bring an action against the state for what's called a declaratory judgment with respect to whether or not the act or the enactment of a new statute is unconstitutional, whether it's as written or as applied. That we get into those issues all the time, where sometimes the mere way that a statute is drafted is unconstitutionally vague or is inappropriate for various number of reasons, and it gives you can facially attack it. Other times your case, and it's always true, it's much stronger if you can get into a situation where you're not doing just a pure facial attack, but you're also talking about as applied. So you're looking at, was due process denied both, or does the statute deny due process both facially as written and also the way it was applied to this individual who may have just had all of their equipment seized from their business because of the nature. And in your situation, the anti-abortion statute that was at issue in Georgia, if they walked in and confiscated medical equipment and the like because it was no longer authorized or could be used, then that individual or that physician or that clinic could make the claim that there was an unconstitutional action and that the statute was unconstitutional both facially and as applied.
Well, that's interesting that you would talk about the physicians and the impact the law could have on their practice. A lot of people don't know this, but Roe v. Wade, sort of the pinnacle abortion case, the petitioners in that case were actually physicians. And they were filing the action saying that this ban on abortion limited unconstitutionally their judgment in practice medicine. And the court did a whole analysis on that function. And since then, it's sort of that body of case law has shifted more to protecting a woman's rights, individual liberties, as opposed to focusing on the physicians. But Roe v. Wade focused very much on the doctor's right to practice medicine.
Right. And we were also looking at the science of it. Is when is the fetus viable? Is it first trimester, second trimester, or third trimester?
Well, that was the standard in Roe. And of course it's changed since then.
Right. Right. Viability of life. And I'm very much, and from a personal standpoint, anti-abortion. I'm very much a pro-life individual. And I guess having 5 children and having known how early that heartbeat was going and that child of mine was in the womb, I can't deny the fact that life exists early. So,
And so here the issue was, in this particular ban they were challenging in the state of Georgia, the ban made exceptions for protecting the life of the mother, but did not make exceptions for rape or incest. And so the ACLU was challenging it, saying, suing these individuals, saying their enforcement of this provision in the representative capacities was unconstitutional because it didn't have the adequate protections to protect a woman, who conceives as a result of rape or conceives as a result of an incestual relationship. And there's no clear ruling here to say that these are prima facie on its face unconstitutional.
Right. That was a procedural ruling. It was just, you can't bring suit against these individuals in this capacity. You need to go back and redraft your attack.
Correct. And the court specifically stated in its ruling, at least according to this article, that the legislature could amend the statute to provide an exclusion of sovereign immunity in this instance. But because the legislature had not done that, sovereign immunity applies and prohibits this action against the state official.
Interesting. Well, there was one more case, and I haven't had a chance to read the complaint yet, but did you see yesterday where the Ottawa high school personnel who were involved in the juvenile court proceedings with respect to the basketball team have now filed suit against the schools, against our district attorney, and against the head of the Board of Education at the time?
I did see that, the superintendent. Yes, I read that article with I was a very highly publicized news event when all that was occurring. So I read that with a significant amount of interest.
Right. And, at least, and I haven't read it. And so I don't know whether Mr. Wilson and his recount of what's in the complaint in his article in Chattanooga.com is complete. And certainly don't expect him to recognize all the niceties of some of the legalese, but it appears that they're making claims on, at least to a large extent, on an individual basis against these individuals instead of governmental, because they're making claims that would fall within situations where employees could be liable because there are intentional torts asserted. Basically, you're looking at malicious prosecution, abuse of process, intentional emotional distress claims, and the like, which is really an unusual approach because usually in these situations, as the attorney for the plaintiff, you're trying to find any way and every way to trigger the liability of the government so that you can access the government's ability to pay the claim. At least from what I've read in this article, it looks like the attorney for the plaintiff has made the decision that this is more an action against those individuals in actions that perhaps were vendetta or were personally driven, and therefore they're not really seeking, at least from looking at the article, to try to necessarily trigger governmental liability.
And I guess one issue too that, at least just from my briefly read the article, I also have not read the complaint, but in general, just district attorneys general, state district attorneys, or state attorneys general are exempt as a prosecutorial immunity, and you're not allowed to sue a district attorney for taking action in his official capacity. And the public policy there is we don't want district attorneys deciding whether or not to prosecute an action in fear of being sued. So the law has a broad immunity for prosecutors. And so I guess one of the initial questions I have, at least with respect to the claims against Mr. Pinkston, is whether this would be prohibited under prosecutorial immunity.
Right. And, I agree. And that's really what they call the public duty exception. He had a duty to the public at large to enforce the laws, not just to the individual students who were involved, but to the public at large, because of the issues and interests of the public in making sure that children in the care of school officials are protected and taken care of. And if something happens, there's a timely report, action can be taken, et cetera. And so I think the public duty doctrine will step in and will cover him with respect to his immunity. I agree with that. They can take the argument that there's a special duty exception, perhaps, or that it goes with outside of all that, and it gets actually into some of the more specific false arrest exceptions to immunity where employees can be held liable. So I'll need to go back and read his complaint to see exactly how they've asserted their claims, but at least from the article, it looks like it was an interesting approach to be taken.
Right. And it of course is somewhat of an unusual circumstance. Normally you're talking about all these individuals were essentially state actors. They were employees of a governmental or quasi-governmental agency, the Department of Education. So a lot of times when we're talking about a GTLA case or a 1983 case, you're talking about a private citizen bringing in action. So this is a little different setup as far as the individuals involved in their relationship to one another.
Sure. And everyone, when you're looking at this and at this point in time, forgets the parents of the victims, and what they were expecting from the state at the time all this happened, and what they were looking to the school system for with respect to the protections and serving as basically in their stead as parents.
And local apprentice,
right? I think when they were on this, which is basically Latin saying, you're in the stead of me as a parent for my child, and you're supposed to be looking after my child and making sure they're safe. And while these boys were doing inappropriate activities to my child, I think one of them says he was washing dishes and the like, and there's no appropriate supervision would be the claim that those parents have made.
Well, and I remember, of course, I don't know the veracity of these allegations, but I remember early on when all this event had happened and there were newspaper articles talking about a culture of hazing at that school.
Right.
And that it had existed for a long time. And so you have all those issues that would have influenced the decisions of the school board members, of the superintendent, and of the district attorney general.
Right. I totally agree. And so it'll be interesting to see how this case plays out. It's certainly it's terrible for all the people involved. It's terrible for the former school officials as well as the current school officials who were involved. And we all can reach out and feel bad for everyone, every time there's a tragedy like we had that occurred up in the Gatlinburg area.
And even with that, police shooting, obviously, as officers of the court, we're always concerned about the administration of justice and recognize, the dangerous job police officers have and their responsibility to go out and investigate potential crimes and protect members of the public. And so even with that, we would also consider, remember the police officers there, that you have to think that they're god awful sorry for having shot a pregnant woman.
Sure. And killed her.
Right, shot and killed her. Right.
Right. So I agree. I mean, I don't think anyone went in with that intent, but again, all you have to do is intend to draw your weapon and fire it. You don't have to intend the consequences. And as a result of that, there's been a horrible tragedy, and that's why our law provides for compensation, because whether it was a mistake or not, there has been a loss and severe damages incurred. So,
and in that hypothetical, or I guess the real case we're talking about, is protecting really the rights of the minor children who are left now without a parent.
Yep, I agree. It's just been terrible. Well, we started all this to come in and talk about some estate issues, and I guess we've got a few minutes left. There's something I've always heard was a poor man's will or trust. I mean, what is that? Is there something that's out there where you can, set up just basically a power of attorney or a POA and basically get everything transferred or taken care of before death?
Well, there are different mechanisms for that. For example, some bank accounts, you can have a payable on death beneficiary designation or joint tenant right of survivorship, and that provides for a title to that particular asset passing pursuant to the survivorship provision or payable on death beneficiary designation. Those are sometimes referred to as Taunton trusts. It's a way of establishing a mechanism for wealth passing upon death without having to use any type of last will and testament.
Okay, and the good thing about that is it's private.
Absolutely, yes. And if other children or natural objects of the account owner's bounty are excluded from receiving it, there could be litigation and it can become public to the extent it's made an exhibit in court. But you're right. If absent some type of action like that to make it public by people involved, it's a private agreement between the account owner, the bank, and the beneficiary.
Right. And which is one of the wonderful things I like when I'm talking with clients about estate planning, about trust, is it allows you to pass things and do it very privately and quietly.
That's correct.
We're to the end of our hour, and perhaps we'll come back again so we can discuss some of the estate issues.
Absolutely, yes.
I appreciate it. And to you out there in the listening public, I hope you weren't disappointed by the discussions of some of the recent issues and litigation that we've seen in the past week. And we'll be back with you next week to discuss more issues here on Legal Bytes.
The Tennessee Valley's news, talk, and sports